Court of Appeals, First Appellate District of Ohio, with the Honorable Marilyn Zeitz presiding, is now adjourned. Please be seated.
Good morning. I hope everyone had a great Super Bowl weekend. I see a lot of smiles. Hopefully the team you were rooting for won, but we won't ask what that team was, okay? So today's Tuesday, February 13. We have 4 cases on the docket. 3 are set for argument. The first case we have is case number C230478, Paul Manter versus Atria, Northgate Park, LLC. If attorneys can please identify themselves and their readiness to proceed.
Good morning. Christina Coral for the appellee.
James Ferris for appellant.
Thank you. The next case we have is case number C230275, State of Ohio versus Kendra French. Attorneys can please identify themselves and their readiness to proceed.
Your Honor, Brian Smith on behalf of the appellant.
Thank you. And the next case we have is, it's case number C230333. It has submitted on the briefs. It is State of Ohio versus Chris Williams. And the last case we have is C230428, State of Ohio versus Brittany, and correct me if I got that wrong, Brittany? Okay, Brittany Sanders.
Attorney Christina Adelaine for
He saw it on the state.
Okay. So Attorney Adeline and Attorney Sauter, I think have you been notified that okay. So we'll be taking just a quick little moment, and then I'll be stepping out and Judge Bergeron will be sitting in my stead, okay? All right, thank you. Okay, Paul Manter versus Atria Northgate Park. Good morning.
Good morning, Your Honor.
How are you doing this morning?
I'm well. How are you?
I am good.
Your Honor, with me is my paralegal Nancy DeBoer, just for the record.
Good morning. So Attorney Ferris, would you like to reserve any time?
Yes, maybe 3 minutes.
All righty. You can start whenever you're ready.
With respect to a statement of the case, Your Honor, plaintiff is Paul Manter. He was a resident at an assisted living facility located out at 9191 Round Top Road, Cincinnati 45251 in Hamilton County. The defendants are CFP Senior Living, Northgate Park LLC, who's the owner of the premises, and Grace Management, Inc., who operates the assisted living facility at that location. The defendants together have been and will be referred to, I think, as either simply Northgate or Northgate Park. In early October 2018, Paul Manter contracted with Northgate Park and became a resident there. He entered as a designated care level 1 for disbursement of or dispensement of medication, which carries an upcharge of $460.
Counsel, can we cut to the language, the relevant language in the care agreement? What exactly does it mean to provide standby or hands-on assistance from a caregiver, and then in brackets, wash back and feet for bath, shower 2 to 3 times a week? What service did Mr. Manter contract for?
The service he contracted for, there's actually, it's Exhibit 5 to, let me back up. When he first went in, the bathing service was to be provided by Care Connections, an outside company, so a third-party nursing facility that would come in and provide, I think they are a skilled nursing, which Northgate Park is not, but they would also provide other services, in this case.
Well, this suit isn't against them, so what did he contract with Northgate for?
He was, after 2 months when he was there, in late January, he was apparently he was not getting bathed, or he was refusing to bathe. As a result of that, a new nursing assessment was made, reevaluation was made in late January of 2019, and the bathing duties were taken over, the assistants were taken over by Northgate Park. So that left the other company out. And there's, I believe it's Exhibit 5 to the complaint on January 23rd, 2019, has a plan for various things, for activities, for dressing, and for bathing. And all that says, personal hygiene, the goal was to be independent. Paul Preference is able to manage his personal hygiene independently. All of the things that are on that plan were the same way. He wants to be independent, like most older folks.
Maybe you're not understanding my question. I just really want to hone in on this specific language. What exactly is in the record in terms of what standby or hands-on assistance and then wash back and feet means? Do we know what Northgate thought that meant?
The testimony of Rose Marie Caldwell, which I don't think is particularly credible on this issue, is that, well, he was just on standby assistance. That's all.
What does that mean? What is standby assistance?
I think it's defined in different ways. According to Northgate Park, the standby assistance means, it could mean as much as knocking on the door and say, Paul, time to take your bath.
What does the record show that standby assistance means?
There's nothing other than the language in the care plan and the evaluation, which is Exhibit 3 and 4 to the complaint. It's a plain language. I would submit to you that if you look at the plain language of what I call the bathing clause, then it says he's supposed to get a bath.
And so the wash back and feet part that's in the brackets, does that go with the hands-on assistance part, the standby part, or both?
There's nothing in his care plan or that evaluation that says this is what the bathing assistance is going to mean. It's not in the record. There's testimony about what that means. If you listen to Rose Marie Caldwell, then and perhaps Stephanie Watkins, the wellness director and the executive director, they would want you to believe that it means, well, we're just going to stand by and watch. We're not going to really do anything to help you. If you talk to Karen Kuntz, who's at LPN at Northgate Park for 20 years, she has a much different story of what that is.
All right, and so are there disputed facts in the record? I mean, it sounds like one witness is saying it means knocking on the door and telling the resident to bathe, and another witness is saying it means actually being there while they're bathing and providing some kind of help to them.
Yes.
And do we know what Mr. Manter thought that this service was for, that he was paying for? Do we know anything about his understanding of this contract?
I don't think Mr. Manter knows. I don't think he's capable of really understanding that. He has some serious health problems. He confuses time and place. He misconstrued.
Now, you said that this is governed by the plain language of the contract. If that is so, then what your client thought it meant to be and what other people thought it was meant to be, is that even relevant?
It is, because Rosemary Caldwell acknowledged that he wasn't getting bathed. And from plaintiff's
But
standpoint,
if it's governed by the plain language of the contract, then why would that be relevant?
because he didn't get bathed. If you look at Dr. Levin's report, he didn't get bathed for months. And as a result of not getting bathed, an ulcer developed on his foot, which it was 3 centimeters in size. There's a photo attached to Aaron Manter's, his son's affidavit, that shows a rather gruesome photo.
Well, is the contract clear or is it ambiguous
As to what hands-on assistance means,
as to what standby or hands-on assistance from caregiver, and then in brackets, wash back and feet for bath shower 2 to 3 times a week? Is that clear or is it ambiguous?
it's ambiguous.
And so then what would we look to determine what it means?
What Northgate Park said it means, and what an ordinary person who looks at that language. Here's my take on this is, when you look
Let
at,
me ask you one more question. Is the interpretation of that provision in dispute between the parties, or in the
Absolutely.
record, it's in dispute?
absolutely.
All right.
And let me clarify that. Is it the interpretation of the language that's in dispute, or is it what he actually should have been getting between those two options that's in dispute? Because there were 2 options that are provided in that amendment with an or in between. So is it the interpretation of the language of what sits in one side of the or and what sits in the other side of the or is it what he was entitled to get, whether it was the standby or whether it was the assistant that's at issue?
I would say it's both. It certainly is based on the language that's there as to what was he supposed to get.
Okay.
There's no record from Northgate Park as this is what kind of bathing assistance you're going to get. It's
So,
just,
so if that is the case, and let's just talk about what he was supposed to get, if that is what is in dispute, how would you read that in light of Section 5.1 of the contract?
5.1,
Yeah, 5.1 gives the facility the responsibility to be making evaluations with regard to your client and to amend the care based on their responsibility to do review and evaluations.
community staff will observe your health status to identify and help you respond to your dietary, social, and personal care needs. Bathing is a personal care need as defined in the Ohio Administrative Code. So they were the community staff, which in this case, if the aides had been bathing him, which they were not, they would have noticed a change in skin condition. He had necrosis, dead skin on the bottom of his foot when he was taken to the hospital on December 29, 2000.
Well, I don't know
15.
that causation, I mean, aren't we getting into a causation issue here? And I don't know that that's been determined or assessed at this point. So
Okay.
we don't know what would have happened because that's not been determined since we're at summary judgment.
Yes.
Before you sit down, I have one other question for you on a different topic. Can you address the difference between residential care facility and residential facility? And I specifically want to call your attention to the license that Northgate held. I'm looking at the license right now, and it uses the language of Chapter 3721, which is the residential care facility language, and it has the term residential care facility on it.
Yes.
How does the license itself play into your argument that this was a quote-unquote home?
It is a home under the definition of, let me see the statute.
Is the license dispositive, or is there other information that we need to consider in determining the character of the
Yes,
facility?
you need to look at 3721 governs residential care facilities. And the license says, the license itself says it's being issued to a residential care facility. Plaintiff wants you to believe that it's licensed under Chapter 5119 and Chapter 5134. 51, just looking at what those chapters are about, 5119 is titled Mental Health and Addiction Services. That doesn't define, that's not even close to what Northgate Park is. 5123 is titled Developmental Disabilities or Residential Facilities. There's a difference between residential facility and residential care facility. In Rose Marie Caldwell's testimony, she point blank, when asked, and that was one of the first depositions we took, said it's a residential care facility. What the court found is that it's a residential care facility and a home. It's both of those. If you look at the definitions under 372101, and if you read much of Chapter 5119 and 5134, 5119 and 34 don't apply to Northgate Park. The statutory scheme is wrong. And then the OA.
Can a single facility be characterized as both or more than one of these things?
A residential, my reading of these chapters and the OAC is that you can't be you can be a residential facility that they're separate and distinct things, a residential care facility and a residential facility. There may be some overlap in some of the language of the OAC, but when you examine the statutory scheme along with the OAC, which kind of puts into place what the revised code says, then it's clear, it's very clear that Northgate Park is a residential facility and not a residential facility.
Right, so it's your position that it's one or the other.
Essentially, yes.
Unless there's any other
I do
questions.
have a question for you, Mr. Ferris. And in your brief, your answer to this question was reason and common sense. But it looks like the trial court relied on that Textron financial versus nationwide, which essentially stands for the proposition if you have a contract claim, you cannot have a separate in your case, negligence claim or a separate tort claim. Can you tell us how we get around that particular case? And it stands for that proposition. We see it all the time. Again, there's a contract claim, and then something happens, somebody gets hurt, and there's also a negligence claim. How do we get around that case, sir?
A couple of different ways.
Other than reason and common sense.
Right. After doing enough research, first of all, there is a common law duty. So with negligence, there's a duty. If there's a breach of duty and then proximate cause and damages, you have a negligence claim. I believe we have all of those things. With respect to common law, the Hunsicker line of cases says that ordinarily a breach of contract is not a tort. However, a common law duty to perform with care, skill, and reasonable expedience and faithfulness is incidental to every contract, and negligent failure to observe those conditions may constitute a tort. In this case, there's duties in the OAC with training of aides that have not been met in this case. There's testimony from the wellness director, Stephanie Watkins, that aides, trained aides, nurses, trained nurses. She didn't train anybody. She's the wellness director is the head nurse. And there's a duty for those people to be trained. And in this case, it's clear on the record that they were not properly trained. There's no records of it, and it wasn't done by testimony of Rose Marie Caldwell herself, who's the executive director.
Well, let me ask you this, Mr. Ferris. Are you saying that with regard to your client's foot, the aide should have discovered that prior to him falling? Was there some indication that there was an issue with his foot?
He has neuropathy, which is a loss of feeling in his legs. If he had been getting bathed and they were helping him with that, they should have seen an ulcer develop on the bottom of his foot, especially if they're washing his feet. So yeah, it is important as to how you construe what that duty is. What does that mean? There's no clear answer to that in the record. It's not in an evaluation that changed from CCOC to Northgate in terms of bathing him. It's just not there. So there's testimony about it, and then there's, look at it. What's it mean? To me, I don't see how you can look at that and say it doesn't mean you got to bathe him. And even if he refuses, what are you going to do? You need to, there's observational requirements and duties under the OAC as well for the aides, for staff members of Northgate Park. And they didn't, if they weren't bathing him, they didn't, oh, guy's crazy.
Thank you, thank you.
Okay, yeah, you answered. Thank you. Thank you, Mr. Ferris. Thanks.
Thank you. Good morning, Attorney Coral.
Good morning,
How are you?
Christina Coral. May it please the court.
How are you doing this morning?
Pardon?
How are you doing this morning?
I'm doing great. Got
All right.
up early, drove down here. There's no snow or anything. I was thrilled. I want to start out with Judge Kinsley's question. So the answer to your question about the contract language is as follows. There's nothing unclear about the contract. We have a situation where Mr. Manter didn't want to bathe. I mean, if you look at the documents, he came into the facility and wanted to be independent. This is an independent living facility. We don't provide medical care, and I'll get to that in a moment. There came a time that he just didn't want to bathe. So he contracted for an additional service, which is one of two things. And there is no conflicting testimony on this point. Everybody testified the same. With that service, you either get standby assistance, which is exactly what Mr. Manter received and that he testified he received.
Let me ask you, what is a standby? What is what does it
Standby
mean?
is-
There's
it's
two different
time-
versions of it.
It's time to take a shower, and now I'm going to stand here and watch you shower. And he testified that that's exactly what happened. The other thing that he could potentially have gotten under this
He
provision
also
of the
testified that
contract-
his back was washed, which is more than standby.
I don't know that he testified that his back was washed. I know that there was guidance into the shower to help him get in the shower, and they stood there and watched him shower. The other issue, though, is then, and we couldn't do it in this case, because Mr. Manter didn't want us to bathe him. He wanted to be independent. That is in all the documents. So this notion of...
So is that in dispute?
I don't think it's
Is it in
at
dispute
all.
what actually, so what I understand your position
Right.
is that the statutory language is clear and unambiguous, no parole evidence, right?
Right.
What's at issue is which one was he to get under the circumstances?
Well,
Am I-
the cost for the
am I-
service is, yes, the
Okay.
cost for the service is one of those two things.
Exactly, one of those two things, right?
Right.
So is it clear, there's no conflicting evidence as to which one because I think there's two issues here, one is which was he supposed to be getting under the circumstances, and the other one is which one was he actually getting? So I think there's two questions here. Are both of these questions clearly, the evidence only sits on one side to answer both of those questions?
Yes, those are both clearly defined. I mean, the reality is, he
I didn't
wanted...
ask if they were defined.
Oh, I'm sorry.
Okay, because those are both issues of fact, are they not?
They are,
Okay.
for purposes of that part of the analysis,
So my
yes.
question is the record so clear and the evidence only sits on one side to answer both of those questions of fact?
Yes, there are no questions of fact. He was not being physically bathed. He was not. There's no question about that. He was receiving standby assistance.
Let me ask you another question that may or might, at some point, his son requested whatever, the standby bathing, but part of that I thought was to wash his feet. And sort of the genesis for him losing his leg was some sort of blister, some swelling on his feet. And if your clients had the obligation to wash his feet, it seems to me they would have noticed the blistering and just called it the black spot that turned into gangrene. How do you address that? Because it specifically said they were going to wash his feet, right? Am I right in that?
No, they were not going to wash his feet. They were doing standby assistance.
Okay,
which
then I
is-
misread that then.
So let's back up a second. So we don't provide medical care. We just don't.
I'm just talking about washing his
It's
feet.
in our contract, right? So if you look at the facts of the case, from October until 3 weeks before the ulcer was discovered on the bottom of his foot, he had people in taking care of his feet and legs. Because we don't provide medical care. He had care connections coming in and taking care of his feet and legs. We don't do that. Our standby assist shower thing was in place before care connections came in and started taking care of his feet and legs. That's not,
Understood, but by this amendment, you contracted, your facility contracted to include the services of hands-on assistance.
no, we contracted to either do standby assist
Or-
or hands-on assistance,
Correct.
wash feet and legs.
Does the wash feet and
Back.
wash back and feet in the brackets, does that go with the hands-on assistance, the standby, or both?
That's hands-on. That's
How
why.
do we know that?
Well, that's because of the construction of the sentence. It's either standby assist, which is just what it sounds like. You stand by and watch, or hands-on assist with the washing of the feet and back. He didn't want the washing of the feet and back.
So if that's the case, then the continuation of that sentence is for bath/shower 3 times a week.
Correct.
So you're saying for standby assistance, we don't know how many times he needs to bath or shower, but for hands-on, we know that it's 3 times a week.
No, I mean, I think that end of the sentence applies to the or, because it's telling the number of times each one of those particular things could take place. But if I could, I mean, I don't
Counsel,
like-
I have another question
Sure.
for you. And since we're parsing language, it would be so much easier if we had a big board or something and we could just look at this together. But I'm going to have to resort to telling you it. So the sentence says standby or hands-on
Right.
assistance.
Right.
And then it's got the other
Right,
descriptors.
right.
It does not say standby assistance or hands-on assistance with the other descriptors. So can you tell me why standby assistance or hands-on assistance are not standalone things? Because I think there's a plausible interpretation of this sentence that says standby goes with assistance and the rest of the stuff. And then hands-on goes with assistance and the rest of the stuff, because standby and hands-on are just separated by or. Do you understand my question?
Well, I can tell you that the testimony has been that this was the practice. I mean, you either get one or the other. Because this is an independent living facility, we don't hands-on assist everyone. So to answer your question, I mean, that was the way we have put this contract into practice as we've used this contract over the years. That's what the testimony was in the case. I mean, that's the way we interpreted this language. But if I could jump. go ahead.
Was he in fact bathing 2 to 3 times a week?
Yes, he was getting standby assist for bathing 2 to 3 times a week.
But was he, regardless of the assistance he was receiving, was he in fact bathing 2 to 3 times a week? Or were there gaps in his personal bathing?
We don't know the answer to that question, but that goes to a great point, because whether he's bathing or not, frankly, is not relevant, because there's no evidence in this case that let's assume he wasn't bathing. Let's assume we weren't doing the bathing. There's no evidence in this case that the ulcer was caused by not bathing. He's got a vascular condition in both of his lower legs, including neuropathy.
But isn't the issue whether it would have been noticed?
Well,
And I
then
know
that's-
you're going to get to the skilled nursing.
Absolutely.
With response to that, You know, and obviously, the position is, you know, of your opponent is that, look at this picture. I don't think it requires skilled nursing to see that something has gone awry when this large ulcer is on the heel.
That's another rub. The large ulcer, I mean, the metadata on those pictures was weeks after he left. It wasn't the day he left the facility. That's not what it looked like. And so the answer to your question is twofold. First of all, he's standing up in the shower, right? You can't see the bottom of his feet when he's standing up. Our expert witness, which is unrebutted via an affidavit, said a couple of things. First of all, we don't provide medical care. Our people aren't trained, especially if someone's standing, right? You can't see the bottom of their feet.
But isn't that an issue of fact for the jury to determine?
Well, no, because it's 100% speculation that had we done something different, the outcome would have been different.
Well, the trial court here never reached causation, right? It didn't need to because it never got past liability.
Well, absolutely, Your Honor, but the court can affirm rulings on different grounds, and the reality is there's zero evidence of causation here. Whether there's no evidence that what we did caused the ulcer to begin with, there's no evidence that what we did or did not do had any effect on the outcome of the case. I mean, remember, he knows that we're not giving medical care. Do you know how he knows we're not giving medical care? Because he's hired his own medical care that comes in from the outside. Our contract says if you need a doctor, you've got to bring in your own doctor. That's exactly what he did.
Isn't there conflicting evidence as to whether this is skilled nursing care or not, as to
Not from our contract.
in other words, the knowledge or observation of the heel, and whether that's alarming or not, or whether that should have been noticed and action should have been taken? Isn't there conflicting evidence from experts with regard to that in the record?
Well, no, the only evidence in the record is from our expert, because the report, the statement of opinion from the plaintiff's expert is not sworn testimony. It's not testimony at all. It's simply a medical report. And the reality is this: the plaintiff's statement of opinion for their expert says this should have been discovered when you're doing skin checks. We do not do skin checks. Skin checks, there's testimony on the record. We don't do skin checks. The contract is very clear. We do not provide skilled nursing care. We don't do skin checks. We don't do observation of changes in the resident's condition. We don't do special procedures of any kind. If you need medication administered differently than orally, you have to bring in your own skilled nursing care. Just like for the care of his legs, Mr. Manter brought in his own skilled nursing care with Care Connection because we don't provide that service. So it's been very clear that our expert witness, who has testimony, sworn testimony on the record, said, when these are developing, our aides, even if we're looking at the bottom of his feet, wouldn't even know what this is. The picture that you're seeing was taken way after he left our facility, and of course it's getting worse and worse and worse. So the reality is there's no
I want to make sure I
evidence of
understand
causation.
part of the argument that
Yes.
you were responding to. Are you saying that the report that was submitted by plaintiff on this, that included this issue, should not have been considered by the trial court, that it didn't meet the requirements of evidence to be considered for summary judgment?
Well, yes, I mean, it's not an affidavit, it's not sworn testimony, it's simply a hearsay report that otherwise is not admissible in evidence, and frankly, it's based upon facts that aren't in the record. I mean, the whole basis of the opinion in that letter is that we should have discovered this when we do skin checks. We don't do skin checks. There's nothing in that report that says, oh, you should have noticed this, because the testimony was Mr. Manter was putting on his own shoes and socks. His son would help him put on his shoes and socks. He wanted to be independent. That's why he's in our facility and not a nursing home.
Counsel, can you address that issue?
Yes.
Can we turn to the license question?
Yes.
And same question for you. Is the license dispositive, or is there something else we should look at?
Well, the license is dispositive of one claim, because one of the claims, and it's the claim that Judge Winkler brought up, and that is this claim that there's a patient's bill of rights that applies to nursing homes, because nursing homes have patients. We do not. So the patient's bill of rights doesn't apply to us, and
Why is that?
well, because we're not a nursing home. I mean, you don't need to look any further than our contract with Mr. Manter that says right in it, we don't provide medical care. We don't provide nursing care other than to pass you a pill to take. That's all we do. If we,
What about this argument under Chapter 3721?
well, so so all of the testimony in the record is as follows. Our prior executive director testified that we are a residential care facility. We're not a nursing home, and we're not a long-term care facility. There's an affidavit from our current executive director that says the same thing. We're licensed as residential facilities. We are not licensed as a nursing home.
Well,
If
your
we
license says you're a residential care facility under Chapter 3721.
Well, right, because that is the overarching section in the code that creates these categories of facilities. It's also in that very statutory provision that exempts us from that. I mean, if we tried to provide skilled nursing care, our license would be yanked. We don't have skilled nursing care. We are not a nursing home. And if you just look at our contract, it says that very clearly. If you do a search on the ODJFS website for nursing homes or extended care facilities, we don't come up, because that's not how we're licensed.
Doesn't the definition of home include residential care facilities?
It doesn't. Not in the context of our licensing. We are not licensed to provide skilled nursing care of any kind. And if we're not
I
providing.
don't think skilled nursing care is the key term. It doesn't the definition of home under Chapter 3721 include a residential care facility, and that's what you're licensed as.
Well, home doesn't mean a residential facility. I don't see anywhere in the statute that it defines residential care facility as a home. Home doesn't include a residential facility. We are a residential facility. That's what we are. That's what we're licensed as. Again, it goes back to this trying to create a cause of action under a patient bill of rights. We don't have patients. We have folks that we assist. I mean, our contract says this is what we help with. We help with.
What is the relevant statute that you are licensed under, that you do believe you're regulated by?
We are licensed under 3721, because that's the statutory scheme by which all of those different facilities are licensed. We are licensed under that facility. We just don't, the patient's bill of rights, which is how they are trying to create a tort duty, does not apply to us because we don't have patients.
What kinds of facilities does it apply to?
Nursing homes and extended care facilities. That's what it applies to. I mean, in the parlance that we are used to talking about, right? I mean, nursing homes is where you go in and you get nursing care and you get medical care and we take care of your medical needs. Our facility addresses dietary, social, and personal care needs, not medical needs. And Mr. Manter knew that, because anytime he needed medical care, it came from the outside. It didn't come from us. Our people are not trained to do skin checks. Our people are not trained to provide medical care. And whether he was being showered or not, frankly, it's a very sad case. It is. But whether he was being showered or not has nothing to do with the outcome of this case. And there's no evidence in the case that cuts against that premise.
Unless there's any other questions.
Thank you.
Thank you.
Thank you.
So, counsel, you have 3 minutes.
Counsel, can you address the definition of home and the patient's rights claim?
Yes.
What
3720
facilities count?
3721, 01A1, I think it is, defines what a home is, and it says residential facility is a home. And it's under 3721.
And then what kinds of facilities are governed by patients' rights claims? Is it homes or is it skilled nursing facilities?
I think home can be a residential care facility or a nursing home. They're not mutually exclusive. But what they're not is Northgate Park, I heard the term
Let me
is
go
an independent.
back. Can the resident of any home raise a patient's rights claim?
I think they can, yes.
And what statute is that, if you know?
The residential status, I think it's in 3721. Patients' rights. I believe, I'm not sure what the subsection is, but it's in 3721.
All right.
But residential care facility is part of 3721, and that's been acknowledged by council. Council refers to Northgate Park as an independent living. It's not independent living. It's an assisted living facility. You don't get there. You get there, you get 3 meals a day. You're not, do you want to be independent? Is that a goal so they can dress themselves, bathe themselves? Yes. It's not, they're not in a nursing home yet.
Is there evidence in the record as to whether Mr. Manter was actually bathing?
In my opinion, no. The only thing he said is that people there were nice, and I was, one time I was taking a shower when and I could hear the nurses. Well, the nurses don't provide the assistance, the aides do. Mr. Manter's testimony is not reliable.
Isn't there something in the record about his back being bathed? Or did I
No, there's
misread
nothing
that?
in the record about his back being bathed.
Let me ask you, Mr. Ferris, my recollection was there were months of nursing notes missing for some reason or another, and one of defendant's witnesses said, well, that's normal, and another witness said, no, there should have been notes. So the point of that is we don't know whether he was bathing or not. Am I correct in that?
That's correct.
Okay.
At least from the nurse's standpoint. The aides were to keep records too. There are no aides records. Their nursing notes are spotty. So we unfortunately, we don't have those records to look at and see on a 2 or 3 times a week basis whether he was getting bathed or not. But Northgate
And
Park.
is it your position that the lack of bathing caused the infection that led to the amputation, or is it your position that the lack of bathing was a missed opportunity to observe the infection that led to the both? All right, thank you.
So unless there's any other questions,
If I can make one more statement, Your Honor.
if it's 30 seconds or less.
30 seconds or less. Counsel came up and said, acknowledged, she started out that Paul Manter was not bathing. He refused to bathe. And then we get into, okay, hands-on assistance versus standby. My question would be, I mean, so much of this is circular, but
Okay, well,
if he was refusing.
Thank you for your arguments this morning. Thank you. Thank you both for your arguments this morning.
Thank you,
We
Your
will
Honor.
take the matter under submission, issuing a timely decision. Have a wonderful afternoon. State of Ohio versus Kentra French. Good morning. Attorney Smith, you can come forward. How are you doing this morning?
Good, how are you?
Good. Would you like to reserve time?
Yes, Your Honor, I'd like to reserve 5 minutes for rebuttal.
You can start whenever you're ready.
Thank you, Your Honor. Counsel, and may it please the court. Your Honors, the issue in this case turns primarily on self-defense. The conviction for felonious assault was against the manifest weight of the evidence because the appellant acted in self-defense in this case, as demonstrated under 2901.05. Once there's evidence that's presented that the defendant, that tends to show that the defendant used, or the appellant used evidence, or used force in self-defense, the state then has the burden of proof beyond a reasonable doubt to disprove that. They have to not only disprove that the defendant did not create the situation giving rise to the affray, but also that the defendant had a bona fide belief that she was in imminent danger of death or great bodily harm, and her only means of escape from such a danger was the use of such force. The appellant was not at fault in this case, and that's the definition this court has provided in State versus Mitchell, and she was not the first aggressor. There were actually two separate incidents or altercations that occurred here. The first occurred outside of the apartment building with the two gentlemen or other witnesses present. The second,
The trial court did determine that she was the aggressor, is that correct?
they ended up
Aggressor.
determining, yes and no. They ended up determining that she subjectively had an honest belief of imminent bodily harm. However, they found her guilty because they determined that that belief was not objectively reasonable. So that was the one box that wasn't checked, I guess, for self-defense here, according to the trial court.
Counsel, the testimony as to the what I guess we'll call the second incident is in conflict. And so how do we weigh the conflicting testimony, especially against the manifest weight standard?
With the manifest weight standard, ultimately the trier of fact has to, since this was a bench trial, the court assumes the role as trier of fact, and they would have to make a determination as to the credibility of witnesses, the credibility of witnesses, and also the weight of the evidence. So ultimately, this court has to weigh that as, I guess, either a 13th juror, I guess in this case, a second trier of fact, to determine whether the trial court properly weighed the credibility of witnesses.
Counsel, can you address the physical evidence that was found by the police department? I'm speaking specifically to the tooth that was found on the stairwell landing, the blood that was found there, and the physical evidence that tends to corroborate the victim's version of events in terms of the altercation happening in the stairwell rather than at the apartment door, as Ms. French relayed.
Yes, and there was actually, I want to address that, and also as a preliminary matter, there was some inaccurate testimony on the part of not only the alleged victim, FH, but also on the part of Jackson. And that was on pages 124 and 181 of the transcript, because initially they testified that there was, I believe, blood spatter found in a hallway, a downstairs hallway of the apartment building, and that was inconsistent with what was testified to by one of the officers who investigated. So again, that goes to weight of the evidence, that goes to the credibility of these witnesses. So yes, there was a tooth found, that was found in the vicinity of the stairwell. However, there was some inaccuracies as far as the testimony that both FH and Jackson gave here that calls their credibility into question as well. As far as the location of this evidence, what was testified to, and the appellant testified to this, that the second incident began when she is near the stairwell. I believe she testified she was near the mailboxes of this apartment building, which I believe were down a stairwell from where the FH was located upstairs. So according to the appellant, FH comes out the door of the apartment, which is up the stairs from where the appellant was, and does a Superman, and lunges at her, at which point she draws her gun and fires a shot that ultimately struck her in the cheek and caused these injuries. So,
didn't the court find that to be disproportionate to the harm that potentially could have been caused by someone, just assumed that this woman lunged at her. Didn't the court find that to be disproportionate, to shoot somebody because someone lunged at you?
Ultimately, yes, because they determined that the belief in imminent bodily harm was not objectively reasonable. So ultimately, the court's determination here was that, in their estimation, the situation didn't justify firing the shot. However, it also has to be looked at in terms of what was the appellant facing at the time that this happened. So they don't.
Sorry to interrupt you, but I just want to be sure that we're analyzing this correctly. So implicit in that finding is the trial court crediting Ms. French's version of events, that there was this Superman lunging attack, rather than assuming what the victim said, that Ms. French knocks on her door and basically shoots her out of nowhere, essentially.
Well, and I believe where the tooth was found, and I believe that actually supports where FH was at the time, that she was near the top of the stairwell. So I think that actually goes to, if anything, I think that tends to show that that's about where approximately where her position was when the shot was fired. So it's actually consistent, could be looked at it as being consistent with what the appellant testified to. And again, there are inconsistencies in not only FH's version of events, but also Jackson's version of events, because they're talking about a hallway, finding this in the hallway, and later one of the officers, I believe it was either Officer Russ or Officer Zopfi, testifies that they didn't find anything in that same location. So I think there's some inconsistencies as to where the physical evidence, the blood spatter and the tooth were found, and that calls their evidence into question, and if anything, tends to corroborate the appellant's version. I hope that answers your question.
It does, thank you.
And just want to briefly touch on our second assignment of error. There was some questioning on Anthony Jackson's prior criminal history. Had to do with whether he had a prior conviction that was admissible under 609B. He was asked about this on page 195 of the transcript. He was asked if he had a conviction that was punishable by more than 1 year in prison in the last 10 years. And he did indicate that he did have such a conviction.
So does he actually admit that?
Yes, it was a brief statement. There wasn't a lot of discussion. There wasn't a lot of expounding as to what this conviction was, but he did admit that. It was page 195 of the transcript. So there was a little bit of, I guess, he did say yes, and then I think he tried to kind of backtrack or qualify that, maybe he might have been trying to provide an explanation as to that, but the bottom line is that he said, when he was asked point blank if he had this type of conviction, he said yes. He said yep or yeah, but he gave an affirmative response that would indicate that such a conviction would be admissible under 609B. And it's relevant here because if that's the case...
Counsel, just letting you know you have about a minute left.
Okay, thank you, Your Honor. I just want to finish my thought with the second assignment of error. It's relevant because if that's the case, the appellant is going to have far greater reason to fear not only Jackson, but FH here, the alleged victim, because she goes back to her apartment. She comes out, according to the appellant, she goes back to her apartment, she comes out, she lunges at her. She could have been going back for a weapon. She could have been going back to grab a gun or a knife. Of course, the trial court might have concluded that that was speculation, but at the same time, it goes to the appellant's state of mind and whether she had an objectively reasonable fear of imminent death or great bodily harm sufficient to use this type of force. And I think so it's relevant as far as making that determination as to what the appellant's mental state was at the time to establish those elements of self-defense.
Did defense counsel object to Jackson's exclusion, the exclusion of the testimony?
The state objected, actually the state objected because it happened on cross-examination, and then the trial court sustained the objection. So we believe that was sufficient to preserve the record under an abuse of discretion standard as opposed to plain error. And I think my 10 minutes is
Let me
about
make
up.
sure there's no other questions from the
Yes,
panel.
yes, if there
All
are
right,
none.
thank you.
Thank you, Your Honor.
Morning, Your Honors.
Good morning.
Mr. Smith. We have a new person to appellate, Norb Wessel. So.
Pleasure to meet
that's why
you.
he's sitting up there.
Thank you for joining us.
On the question about what was the physical evidence, they actually found a shell casing and a human tooth on the initial landing, up the stairs, human tooth, blood splatter at the apartment of Ms. Hodge. Again, bone fragments or tooth portions and blood evidence. So it was in 3 separate locations.
How does that affect the calculus here, if at all?
I do not believe it changes the state's position at all. And I don't see how it would prove anything the defense is putting forth. I don't think it helps that argument at all. You asked about the conflicting testimony. I assume you will get the pictures that show you've got several staircases. And so when you take, I'm reading it, and someone will talk about going up the staircase and at the landing, and it gets very confusing. But I don't think ultimately that really had any effect on the ruling in this case, because the judge is the judge of the credibility. The judge gave the benefit of the doubt to the defendant in many, many points on this, and said, yes, I find you were not, you didn't create this. Even though both women were saying the other one created it. And she said, I do think you had a mistaken belief, but honest, that this woman was going to cause you harm or cause you great bodily harm. But then she lays out as clearly as can be the facts of what was testified to and saying there is no way this was a reasonable belief. The defendant said the woman's hands were out. Ms. French said, I saw no guns in her hands. I felt no threat.
And within that, the trial court also discussed something about it being disproportionate, that the use of the
When she said
firearm
that,
was
yes.
disproportionate to the threat.
And the judge was so clear, even after there's a lot of discussion in the Rule 29 argument, and then that went into closing arguments, where, the judge laid all of this out, what her thoughts were, what the evidence was, and they had a debate back and forth about all of this, and then she was very clear in her entry. And she said, yes, it was not a reasonable belief, and it was absolutely disproportionate to the threat of maybe this woman lunging. And
So, your position, I assume, is going to be, well, it couldn't have gone either way. It could have only gone one way, right? But even if it could have gone either way, how does that go into the calculus on our review?
if what could go either way?
The objective belief.
Whether it was reasonable? The state only needs to prove one of the elements, whether it was an honest belief but mistaken, or even if it's honest, that doesn't mean you were entitled to use the force to shoot. She was not entitled, even if her belief had been found to be honest, which is what the judge
Which is the
said.
subjective.
But because the judge found it was not reasonable, then the defense has not proven self-defense.
And what I was asking, and I don't think let me ask it a little different, was even if there was evidence, both sides, on that subjective belief, right? And the trial court then determines that subjectively it was not reasonable. How does that go into our calculus on review?
Well, I believe that what the review is on weight of the evidence, and whether the judge created a manifest misjustice or lost its way. And clearly, I would say it did not. You're applying the weight of the evidence standard.
Doesn't that require, to piggyback off of Judge Zayas' question, doesn't that require that the evidence be so incredibly one-sided that the trial court could not have reached any other conclusion?
Yes.
Do we have that here?
No, I, obviously, in my brief, I don't believe that you do.
And why not, if you could just summarize that for us? Why not, as to the objective belief?
Even if you look at solely the defendant's testimony, she was saying all along that she carries a gun with her all the time, and that in this situation, she felt no threat, she saw no gun, and that the woman was simply putting her arms out and was going to fall. And there is no interpretation that that act could have, that you could reasonably believe was going to cause serious bodily harm or death. It is in the record, there's a size difference. Defense counsel even brought it up, saying the victim's at the top of the stairs and is a smaller woman, and the defendant, because of her size, could not have run up the stairs, say, to attack her. And it doesn't add up. It just, it's giving credit to everything the defendant said about how things happened and what the evidence was.
Can you address the 609 issue? Did Jackson actually agree that he had a felony punishable by more than 1 year in prison?
No, Your Honor. Defense counsel, who said she didn't even know what his record was because she couldn't figure out how to read it. And she said, I just decided to ask questions anyway. She said, did you have you been convicted of a crime punishable by more than a year? He kept saying, no, no, no. And she said, are you sure? Are you sure? And finally he goes, well, do you mean the domestic violence against me? Yeah. He goes, I had a case, and he describes it. But nothing could be interpreted as that being a felony. And you have to see, it is a bench trial. So even if the judge says she didn't consider that, she was there and heard it, but that's what she made the determination. It was not admissible in the record. And nothing in her decision relied on Jackson's testimony. So it was legally inconsequential.
Would Jackson need to have said, yes, I have this kind of conviction in order to preserve this issue? Or would we need some kind of extrinsic evidence that he, in fact, had the right kind of felony to trigger the rule?
There would have had to have been more. And in many cases, the defense will have the records of the witnesses. That defense counsel did say she had it, but wasn't sure how to read it. The implication is that she did not think he had any of these felonies, any felony. And she said, I just decided to go ahead and ask, and since he's giving me details, and he gave details of domestic violence, which would not have helped his credibility, whether it was a felony or not. That was in the record.
So the trial, I want to paraphrase back what I'm hearing just to make sure I understand. It's your position that the trial court understood that Jackson had a history of domestic violence,
Yes,
and that was in the record?
that is in the record.
Thank you.
Was
What
there
I think
anything,
is important is that she didn't rely on anything in Jackson's testimony anyway.
well, Ms. Lappai, the opposing counsel indicated that the domestic violence had some bearing on the defendant's use of the deadly force. Was there anything in the record saying, I was afraid of him, he's a bad guy, that's why I shot her? I mean, I didn't see it in there, but I'm just asking if you saw anything to that effect.
You're talking about the defense?
I'm talking about the defendant saying, I think it was,
Yes.
name was Jackson, saying, yeah, I think she's heard arguing, she's heard this, she's heard that. But was there any indication in her testimony that whatever she heard going on in the apartment below had any bearing on her decision to use deadly force against another person.
No, but she did say, the defendant did say, I heard that he ran around Jackson, ran around with the gun, chasing Hodge, either maybe in 2021.
Okay.
And that's the most connected it could be. And she only made everything supposition because Jackson never came out at the time.
Okay.
I think that's.
You still have 5 minutes,
That covers
but
my head.
but you're welcome to.
Thank you.
Okay, thank you. And counsel, you have 5 minutes.
Thank you, Your Honor. The trial court may have given the benefit of the doubt to the appellant on some of these elements, but the bottom line is the conviction. They found the appellant guilty, and the conviction was against the manifest weight of the evidence. And to answer a question earlier, if the objective belief could have gone either way, the appellant has to be found not guilty in that situation, because once the appellant presents evidence tending to show that she acted in self-defense, the state has the burden of proof beyond a reasonable doubt. This is a case where castle doctrine applies because the appellant lives in this apartment complex.
That wasn't argued below, was it?
I believe, I'm not sure if the words castle doctrine appear in the transcript. However, it would apply in this case because she doesn't have any duty to retreat in this situation. She has no duty to retreat. She's in her own residence. I believe that did come up. There was a mention of at least that she was at her residence. Whether it was specifically mentioned as to castle doctrine, I'd have to double check. But the state has the burden of proof beyond a reasonable doubt. So if it's
And the trial court did mention that it happened at her home.
yes, this
I mean,
was
it seemed as if the trial court had taken into account the castle doctrine based on what the trial court articulated in rendering its decision.
Possibly, Your Honor. However, it goes to the state's burden of proof here, and if the court found that the belief was not objectively reasonable, then that would render the conviction against the manifest weight, because castle doctrine and the lack of a duty to retreat is a factor in that calculation. As far as there was a mention that that the FH was putting her arms out going to fall. She wasn't just putting her arms out going to fall. She was lunging at the appellant from the top of a flight of stairs. And there was very specific testimony from the appellant as to this. She testified that the alleged victim, FH, put her foot on the top of the landing and lunged at her. So this is different than she just fell forward. This is a lunge. This is an attempt to do serious bodily harm, considering the fact that she's coming at her from a height. She's willing to, frankly, risk serious injury to herself by lunging at her from this height. And at the time she does this, size doesn't matter, because even if there's a height difference, if there's a weight difference, if FH crashes into the appellant from the top of a flight of stairs, even if she doesn't have a weapon, assuming for the sake of argument, there's a potential to kill her, to do death or serious bodily harm. I mean, she could crack her skull open on the floor from such.
Wouldn't that be mitigated by simply moving aside as opposed to shooting?
Not necessarily, Your Honor. And at that point, the appellant has to make a decision as to whether the circumstances would warrant the use of deadly force in this situation. We would submit that this is a case where that standard is met, where it's an objectively reasonable belief given those circumstances. If she's coming at her from a height. She's coming down to crash into her from the top of a flight of stairs, even if, for the sake of argument, she doesn't have a weapon. And there was some testimony that whether her hands were open, whether there was a weapon in her hand. But at this point, the appellant doesn't know if she has a weapon on her. But even putting that aside, if she's coming at her from the top of a flight of stairs, willing to risk injury to herself with such animosity that she's willing to do this, there's an objectively reasonable belief in death or imminent great bodily harm at that.
Counsel, you have about a minute.
Thank you, Your Honor. And I just want to touch on the second assignment of error briefly. Jackson said he did have this type of conviction, and if a domestic violence can be punishable by 1 year or more in prison if it's a felony. So that implies he had, if his conviction was for domestic violence, that implies he had more than one, which if anything heightens the not only the contribution to the appellant's state of mind, but also the error of the trial court in not letting it in. And so, the trial court sustained the objection here, so the appellant's counsel couldn't follow up, couldn't present a certified copy or any follow-up evidence. It should have been.
Counsel could have proffered in the record that they had at that point, right?
Well, yes and no. If they question in the trial court, once the trial court sustained the objection, then they may not. There's no indication the trial court would have been willing to let in a proffer at that point. Could counsel have asked for a proffer? Yes. However, the trial court may or may not have let that in. So it should have been consequential, even though it should have been consequential based on these circumstances and based on the testimony and that's in the record and the surrounding circumstances. And I hope that answers your question.
It does, thank you.
And I'll take any questions with my few seconds I've left.
Thank you.
Thank you, Your Honors. We'd ask this court reverse and remain. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a wonderful afternoon. We're going to take a brief recess. You don't have to, it's okay.
Just going to stand.
No, if you want to.
My watch told me I had to stand.
Good morning, everyone. We're here on our last case, which is in re Sanders. Is that an alien? Good morning. How much time would you like for rebuttal?
3 minutes, please.
3 minutes? Okay, you may proceed when you're ready.
Again, good morning, Your Honors. Mr. Souter, may it please the court. This case involves Ohio's post-conviction tool called the Certificate of Qualification for Employment, or CQE, under Ohio Revised Code 2953.25. We're here because the trial court abused its discretion when it denied Brittany Sanders' CQE petition without finding that the statute's rebuttable presumption for granting the petition had been rebutted by clear and convincing evidence that she had not been rehabilitated.
So, counsel, I have a question about that.
Yes.
So in looking at the lineup of entries, it appears that the trial court's order merely adopts the magistrate's order without further explanation.
Correct.
And then looking at the magistrate's order, which is a little bit more detailed, that order, the magistrate's one, does make a finding that rehabilitation has not been proven by clear and convincing evidence. The sole explanation for that is that Ms. Sanders has not regained custody of her children. So given that courts speak through their entries, and that's the lineup of the entries, how is it not the case that the trial court did make a finding that there was no rehabilitation?
So the basis for the last hearing that this appeal stems from. That was a objection to that original magistrate's decision because Ms. Sanders did not agree that solely not having custody of someone's children is clear and convincing evidence that someone is not rehabilitated. So yes, that is the only entry that provides that very brief sentence, but the transcript and evidence today from the last hearing that we were at in front of the trial court, that fleshes out more information to push back on that finding by the magistrate judge that lack of custody of children is not clear and convincing evidence that somebody is not rehabilitated. And if anything, the trial court that this appeal stems from did not find that Ms. Sanders is not rehabilitated at all. If anything, there was quite a bit of turmoil during that hearing.
Well, it made the finding in its written entry, but in court, it might have explained its thinking and logic and how it got to that finding in a different way. And I understand that there's a real schism between what happened in court and then what the entry says. But I still think the trial court made the finding that there was not rehabilitation by clear and convincing evidence in its entry. Can you address that?
I think I'm a little confused by the question. Are we talking about the magistrate's, the first entry that says lack of custody?
Yes, and then the trial court adopts that entry.
Correct.
Well, let me ask you this, ma'am. Wasn't there testimony that your client thought her children were doing very well where they were, and she never did seek custody with regard to those children?
Yes, Your Honor.
Okay, I think that's the gist of the question.
Okay, yes. Apologies, I was trying to understand. The concept of whether or not Ms. Sanders has her children, even the very first hearing in front of the magistrate, that was only asked by one question, point blank, do you have custody of your children? My client answered no. There was no follow-up questions about that by the magistrate. There was no fleshing out of that concept.
And is there anything in the record, and I didn't see anything, that would indicate that there was some effort, there was some custody proceedings and that she was rejected for some reason?
That wasn't in the evidence.
Okay.
That conversation never happened. It was just a factual question, do you have custody? Ms. Sanders said no in front of the first magistrate. When that conversation came up again in front of the trial court, she described her relationship with her children, how involved she was with her children, but there was no conversation about whether she's attempted to get custody and has failed, whether there's a reason why she doesn't have her children at this moment. It was simply factual. Do you have custody? No. So this is why Ms. Sanders argues that that is not clear and convincing evidence of rehabilitation because no wrongdoing is discussed in any of the hearings.
Let me ask you a question, like a predicate question on collateral sanction. And I'm trying to determine what your client's collateral sanction is. And the definition of a collateral sanction says means a penalty, disability, or disadvantage that is related to employment or occupational licensing, however denominated, as a result of the individual's conviction or a plea of guilty to an offense, and that applies by operation of law in this state, whether or not the penalty, disability, or disadvantage is included in the sentence or judgment imposed. And some of the cases deal with professional license of a physician, an attorney, et cetera. So do we presume that by virtue of the fact that your client was convicted of a felony, is that in and of itself the disability?
Not
Or
necessarily.
the sanction, I'm sorry, the
Not
collateral
necessarily.
sanction.
Not necessarily, Your Honor.
So what is your client's collateral sanction then?
There are many. So the way that the law is structured, individual criminal convictions, like for example, my client was convicted of a felony endangering children. So that statute number carries a variety of civil disabilities. So for example, very specifically to become a home health aide is specified that somebody who has a conviction of felony endangering children cannot get that license. So it is specified and it is attached to my client's specific conviction.
Okay, and that's what the trial court seemed concerned, that your client may seek employment in a capacity observing children or elderly people. And, okay, so if that's removed, she could do that, is that correct?
So it's not a magic wand, Your Honor. So if she does get a CQE, it does turn mandatory disqualifications into discretionary ones.
Right.
And so what, I was having trouble figuring out what is the basis for the trial court's determination that she was at least partially not rehabilitated, because I mean, the record was a little, the transcript was a little confusing on that point, but what is your perspective on that?
I would say that actually reflects the confusion and turmoil the trial court was dealing with, because there is this standard that the court has to find that someone's not rehabilitated, but there was a lot of information presented by my client that shows a lot of progress. She did mention about how much therapy that she received when she was released from incarceration, 4 years of therapy, twice every 2 weeks. So that amounts to almost 200 plus sessions. She provided additional information about her relationship with her children, how she's caretaking her grandfather. She even went that extra mile to say how hard she's working with her 2 jobs, working 60 hours a week, but still finds time to be involved in her children's life. So with all of that information, it was difficult to understand the trial court's reasoning when there's nothing in the evidence that shows that she has gotten into trouble ever since her felony conviction. She's had no criminal conviction since her felony conviction. There was some mention about a few traffic infractions and a dismissed case that had nothing to do with the conversation at hand, so that was confusing and troubling. There was also conversation about Ms. Sanders' mental health diagnoses, which went into conflict with what she said about her mental health treatment and how she graduated from therapy. So it is confusing even for us to understand, where did the evidence come that especially amounted to clear and convincing, which is a higher standard for preponderance, that amounts that says Ms. Sanders is not rehabilitated. I mean, that finding didn't happen. If anything, the trial court was trying to grant a CQE partially, which can't be done. So I'm not sure how Ms. Sanders can be rehabilitated and not at the same time.
And under the statute, rehabilitation is an all or nothing status, right? It's not a partial status that can be achieved.
At least for the CQE statute. And I can understand if the trial court is more used to the record sealing or expungement statute, that's formatted in a different way. But with the CQE statute, especially with the rebuttable presumption, we're just looking to see is there evidence that someone is not. If the language was shifted to say, to show that somebody's rehabilitated to the satisfaction of the court, that language I can understand. There's a bit of a sliding scale, more factors and discretion can go into it. But the way that the statute is structured, it's clear we just need to find evidence of someone who's not rehabilitated, and that wasn't found here.
And at the hearing, the trial court appeared to singularly focus on the nature of the offense. And I have to say, I'm somewhat troubled by the fact that the trial court had submitted a recommendation at the very early stage of the case recommending against granting this CQE and highlighting the nature of the case and the punishment that had been imposed. And I note that that is outside the scope of Section B5B of the statute, which contemplates other courts outside of the offense that the application is being asked for. So it appears that the trial court had already made up its mind before considering any evidence in the case based solely on the nature of the offense. How do you respond to that?
I also find that deeply troubling. It's unfortunate, especially when we're taking into consideration why are we here. This isn't an expungement hearing. This is somebody who has made progress, who's looking to continue to make progress with the assistance of a CQE. So the sentencing judge, when they're filling out that survey, they only know who Ms. Sanders was back when she was sentenced. And that's a totally different person than who's applying for the CQE today.
Doesn't the statute direct that survey or questionnaire is supposed to go to other courts and to collect information outside of the offense besides the one that the petition is being filed in? Why would there be a need to send that questionnaire to the sentencing judge in the same case?
That's a great question, Your Honor. Where I think that the part of the statute that allows for that to happen is subsection C1 of the CQE statute that allows the court to order any report, investigation, or disclosure by the individual. Again, that's a bit of a stretch. I'm not sure, what the court would gain by asking the sentencing judge, especially when the magistrate gets a chance to do their own investigation at the evidentiary hearing. I'm not sure, if anything, if I can go on a limb and say that if the law can be changed in that way, that would be better, especially, with cases that are even dated, perhaps it's not even the same judge anymore. It's difficult for the sitting sentencing judge to then, provide that kind of feedback. I'm not sure how that would be helpful. I don't know if I answered your question, but I agree that it's also troubling, and I'm unsure what the reasoning for that is. To touch on what Judge Kinsley said about the trial court talking about the seriousness of the offense, I would like to touch back on the case that was decided by this court not too long ago, State v. GH, which is talking about the record sealing and how the nature of the seriousness of an offense cannot be the sole basis to deny an application to seal records. And I know that that's not about the CQE, but I would say it's pretty comparable since they're both post-conviction tools created to assist somebody to overcome their barriers for criminal records. But the reason I bring that up is just to finalize, and I see this is my time. But the fact that the trial court based this decision on the seriousness of the offense is an abuse of discretion and inappropriate in this way, because this court has said that can't be the sole reason. If the legislature wanted that to be a consideration, they would have included that in the statutory language, and that's not here. So Ms. Sanders respectfully asked that this court reverse and remand with instructions to grant the CQE because of this abuse of discretion. Thank you.
Great. Thank you. Mr. Sutter?
May it please the court, counsel. I don't really have a lot to add to what I have in my brief. I would just note some of the questions that the panel has had. There's no requirement that the trial court make a finding on the record that the presumption has been rebutted. And I think that the finding in its entry, it's axiomatic that a court speaks only through its record or journal entries. And I think that the finding with respect to the magistrate's decision was proper, and it was
Counsel,
sufficient.
can we unpack that a little bit? So I asked your opponent questions about the lineup of entries, and then we have this hearing, which is in a completely different direction. So the lineup of entries highlights custody as the basis for non-rehabilitation and custody only.
Right.
And then we get to the hearing, and there's this much more robust and different dialogue about non-rehabilitation, and maybe she's rehabilitated for some jobs and not others, and the seriousness of the offense is playing in. How do we analyze this, given that we've got a series of entries and a hearing that maybe don't line up?
Yeah, I think part of the disconnect is that there was a variance between what the applicant said during the first hearing and then the evidence that was adduced at the hearing before the common pleas court. I think the focus at the first hearing was whether or not she could get a job in health care, child care, and that sort of a thing. And I think that kind of shifted when it got in front of the common pleas court, where she said, no, I want to go into medical billing and that sort of thing, where she wouldn't have direct contact with children or patients or be in that kind of a caregiving capacity. So I think that's a big reason why things shifted in the second hearing and why the court went into
But what is your perspective on what is the clear and convincing evidence that shows that she's not rehabilitated right now?
I think there are three things, Judge, and I would note, of course, that the court that had made the ultimate determination in this case was the same court that presided over the offense that happened, the child endangering offense. So the trial court was intimately aware of the facts of that case. As the court knows from the record, there was a permanent injury to the child, for which the applicant was sent to prison. So I think that played a big part in it. And unlike the cases that are decided under the expungement statute, I don't think there is anything that explicitly from this court to indicate that the nature of the offense cannot be the sole.
Well, but I think that's problematic, though, just because, like, the legislature has said, notwithstanding the fact that you have this offense, you can apply for the CQE.
Yeah.
And so if they were saying this offense is so serious that you can't apply for the CQE, then they wouldn't have included this whole structure. So I feel like that's the problem I'm having with a fixation on just the nature of the offense, because then how could she be the most rehabilitated person on the planet, and then you could say, well, too bad.
I agree with that, Judge, but I think that the seriousness of the offense can be taken into consideration. I think there could be, it could meet the elements of child endangering in any number of ways, and I think the trial court, in looking at the facts of this case, found it to be especially problematic in that it was her own child, it was a very young child, and it resulted in permanent injury. But I don't think that was, I'm
Counsel,
sorry.
doesn't the seriousness of the offense in some sense inform rehabilitation? Like it says a baseline for rehabilitation. It tells us what's needed for the person to overcome what's happened.
I agree with that, Judge. And I would just note that this is an abuse of discretion standard, and the seriousness of the offense wasn't the only thing that the trial court looked at. I think the trial court was skeptical about the notion that somebody who graduates from therapy no longer has a need for assistance, and I think that the trial court expressed some skepticism about that.
But I guess on that point, that was something else I was kind of curious about. Like, was there any countervailing evidence that she has a present need right now?
No, Judge.
I mean, 4 years of therapy that's a long time.
Right.
And it's not like she went in for the 2-week crash course and declared that she was cured.
I agree, Judge. I acknowledge that. I think that's right. I would just emphasize that the third prong of the rehabilitation picture here was the custody issue. I don't know how much hay we can make of that because I think the applicant did explain that pretty well. And I would just note for the court that this is an abuse of discretion standard, and I think that it might not be the decision that this court would have rendered, but I don't think we can say that it's so arbitrary, unreasonable, or unconscionable that it constitutes an abuse of discretion.
Counsel, what about this recommendation that was issued by the trial court early on? Can you help unpack that for me?
The statute's pretty broad about who can have input on these. It specifically says other courts, but it also there's a catch-all provision that permits any report that would be helpful to the determination. And I think in this case that's probably why the trial court was asked to weigh in on this. And I think that any indication that she was prejudiced or that she had already made up her mind about this, while it could be considered troubling just when she weighs in at the beginning, but I think the subsequent hearing during which a trial court heard evidence and gave the applicant every opportunity to explain her position and the trial court expressed an open mind about this. So I think that any fear of prejudice or bias in this case was alleviated by the subsequent proceedings.
Do you know, and I realize this may not be in the record, I'm just asking if you know, do these, as a matter of course, go back to the sentencing judge, or are they re-rolled and it just randomly went?
I don't know that either, Judge. That's a good question. I thought about that, but I didn't see anywhere in the statute where it indicates how it was rolled. I would just note that in this case, I think what the trial court was worried about was that kind of different from an expungement. When you give somebody a certificate, a CQE, it's sort of putting the court's seal of approval on the determination that this person is worthy of employment. And I just think the trial court wasn't ready to go there with respect to certain occupations in this case. And I think that was probably where the decision was made.
Thank you.
I would just ask the court to affirm the judgment of the trial court, and no further questions. I'll rest on my brief. Thank you very much.
All right, you have 3 minutes.
Counsel, do you know, are these re-rolled or does it go back?
It depends. These don't get appealed very often. There is the case in the 6th District with In re Duran that I cited in my brief where, because the wrong part of the statute was applied, there was an ask to be remanded without, an automatic instruction to grant because it was more of an issue of using the wrong standard earlier. But we don't have that problem here. It's not that the wrong standard was used or not used. We're working with a trial court that already made its decision coming to the bench about who they think my client is. So not thinking that someone could ever get past their mental health issues is problematic. Not thinking that somebody could ever work in healthcare or with children again is problematic when there's no evidence, and there wasn't even one before the original magistrate's decision was made. So when we're talking about clear and convincing evidence and what Ms. Sanders is asking for today, absolutely right. Like, this CQE is not guaranteeing that she's going to be able to get the job of her dreams wherever she wants to. It's an additional tool to help her overcome barriers. And it's challenging when she can come to in front of her original sentencing judge and show so much progress, and yet that wasn't acknowledged, and if anything, there wanted to be caveats to getting a CQE granted, is an abuse of discretion. I'm not sure how helpful it would be to remand this and ask for the same process to happen again. I would ask, for this to be remanded with instructions to be granted, because Ms. Sanders has lost a lot of time already with all of this process. As it's been 14 months since she filed her initial petition. That's 14 months that she hasn't been able to make the kind of progress she wanted.
Would the trial court have been able to ask for one of these reports from the custody court to gather more information?
I would argue yes.
And it did not do that, did it?
No, not at all. There wasn't even any line of questioning about, well, why don't you have custody? That conversation didn't happen. It's not in the evidence. So very much, if the trial court wanted to say, I'd like to continue this, I'd like to bring people who are involved in this, get more witnesses, more reports on this, I want to be informed before I make a decision, absolutely, I would never argue against the court. I wouldn't be here for that. But none of that happened. If anything, so much conversation and evidence happened ahead of what the judge was explaining was the problem. Ms. Sanders was actually confused when we got the decision that we did, because it didn't match with the line of questioning. So this is why, Ms. Sanders argues that this is an abuse of discretion, that there isn't clear and convincing evidence that she's not rehabilitated, because the record reflects that. If the judge wanted to hear more about the custody situation, wanted to hear more about her therapy progress, all that information could have been provided, but that didn't happen. So this is why she respectfully asked for a remand and instructions to grant.
Let me ask you a question,
Yes.
ma'am. Did this trial court ever go through the steps necessary to give rise to the rebuttable presumption that your client qualifies for the CQE? Did the court actually go through that analysis? Because if they did, I didn't see it.
No, they did not. So at the beginning of the hearing, part of my presentation was I did remind the court about that part of the statute. I did say the rebuttable presumption can apply to this because Ms. Sanders, she was released from prison in April of 2014. Post-release control was ended in 2015. So by 2022, enough time had passed, the 3 years plus the 1 year waiting period, enough time had passed, the rebuttable presumption plays. But that analysis didn't happen by the trial court. If anything, the trial court had its own analysis and based it solely on seriousness of the offense and the mental health diagnoses, which the statute does not support this assessment.
Yeah, thank you. Thanks.
Thank you.
Thank you.
Thank you.
Thank you both for your arguments this morning. The case will be submitted. We'll get out a timely written decision and hope everybody has a great day.